What were you drinking then?
Twisted tea, Your Honor.
You just are continuing to consume alcohol. Quite frankly, need to go inpatient. I mean, you know you can't do this on your own.
Correct, sir.
Mr. Duncan is the sole care provider for his 95-year-old mother. I don't necessarily disagree with what this court just stated, and I don't think Mr. Duncan does either. Would the court consider allowing him to be put onto a scram tether?
My point in that is he's highly intoxicated during these films. So that's certainly a concern if he were to be released even on a scram tether.
This defendant walked into court acting like he could outsmart the entire justice system with a few flimsy excuses about his drug tests. It still shocks me how some people treat a court hearing like it's optional homework, especially when they're already tied to a serious criminal case. The prosecutor barely has to lift a finger in this moment. The fact alone make it painfully clear this man has no business walking around free. He's exactly like that friend who gets caught red-handed and still insists they're innocent even though everyone knows what really happened. Tell me in the comments if you think people like this deserve another shot at bond, or if zero tolerance is the only thing keeping the courtroom from falling apart. Let's get into it.
Just state your name for the record, please.
Dustin Duncan.
All right. Your Honor, thank you for recalling this matter. So based on Mr. Duncan's appearance, I would ask the court to withdraw the bench warrant.
What was his name?
There's a bond by.
Yeah, no, I see it. Well, you see the violation. The violation was the reason that I issued the warrant in this case.
Right, Your Honor. I've discussed the bond violation with Mr. Duncan. And Your Honor, to his credit, he did contact his community corrections agent and admitted.
When did he do that?
To consuming alcohol. The report indicates that he did, or it may have been the email actually that was sent out by Mr. Casey, where it indicated that Mr. Duncan did call him and admitted to drinking a twisted tea on September 13th, which is what ultimately led to the positive test on that date. And then obviously we do have other issues. I'm aware of that, but at least he did admit to consuming alcohol to his community corrections agent. I can tell you that based on my discussion with Mr. Duncan, he has started attending some meetings with the Alano Club. He has reached out to Home of New Vision. He's an admitted alcoholic, Your Honor.
Right, Pickett.
I understand all of that, but my other problem is that given the other sort of mistest, I mean, what about you say the twisted tea on the 13th. What about on August 30th? What were you drinking then?
Same twisted tea, Your Honor. I've contacted Home and New Vision.
Well, I just said that, but you're welcome to say it if you'd like to.
No, I didn't. Contacted Mr. Leroy Pickett with Home and New Vision for a sponsor. I had 4 years clean and I relapsed. I know firsthand I need help with it.
Well, I understand all of that, sir, but so here's part of the problem that I'm having. Not only is there then these tests, he also has then missed tests, of which I would have to assume you're drinking.
Yes, I was.
So I'm going to ask you this, all right?
Okay.
I have a bunch of missed tests. But on August 30th, I have the alcohol shows up. On September 13th, alcohol shows up. And we have more missed tests. So between, I guess, the 16th, the date of this report, and the date you went on the tether back in August, how many times have you drank?
6 or 7. Maybe
Yeah.
8. I had 2 missed tests. I was in the hospital, but I did. Yes, I did.
You just are continuing to consume alcohol. And you're playing with the testing so that it appears as though it's just a missed test, when in fact, what it is you're drinking. Quite frankly, need to go inpatient. I mean, you know you can't do this on your own.
Correct, sir.
Mr. Bowling.
Your Honor, Mr. Duncan is the sole care provider for his 95-year-old mother. I don't necessarily disagree with what this court just stated, and I don't think Mr. Duncan does either. Would the court consider allowing him to be put onto a scram tether?
The moment the prosecutor brings up how he was out in traffic, waving a knife around, the entire sympathy act just disintegrates. You can't stand in front of a judge talking about having one drink when your actual behavior could have put half the street in danger. This is exactly the kind of thing that gets people locked up instantly, and somehow he still thought asking for a tether made sense. You can tell the judge is completely done with the downplaying. You see it in the way he stops even pretending to consider the excuses. The attorney is doing what he's supposed to do, trying to soften everything. But cases like this just can't be polished up no matter how you try. Watching the defendant sit there as his entire sobriety story falls apart is rough. I know some people in the comments will say he deserves another chance. So tell me why, because I see that argument under every video about situations like this. Anyway, let's get back to it.
The reality is, in this type of circumstance, that doesn't help.
If nothing else, maybe it would be a reminder with a device on his leg that maybe he needs to call a sponsor if he feels like he needs to drink, or that he needs to attend an online AA meeting at any time of the day. Maybe the tether on his body would give a little bit more reminder than the SoberLink sitting on the nightstand table or the couch side table.
People have some concerns that you'd like to hear.
Yes, go on.
Well, the allegations include that Mr. Duncan was highly intoxicated at the time, walking into traffic, wielding a knife, trying to punch cars, making statements to incite a fight, continued that type of behavior when police arrived to take him into custody. My point in that is he was highly intoxicated during these felonies. So that's certainly a concern if he were to be released, even on a scram tether. At most, I would think the court could maybe consider a release to long-term inpatient treatment if you were to take him into custody. Thank you.
To adjourn the defendant's probable cause conference to September 30th, 2025, 9 a.m. And at this time, given the violations, defendant's bond is. Thank you.
This hearing showed exactly how fast things can flip in a courtroom. People think they can outsmart the system. And yes, addiction is real. But once you put the community at risk, the judge has no option except to shut your freedom down. You'd be surprised how many people land right back in custody because they won't be honest about a slip before everything snowballs. The judge did exactly what the law requires here. Protect the public first and leave the emotions out of it. It's hard to feel sympathy when the defendant kept pressing his luck until there was nothing left to defend. Watching him get remanded that fast should be a wake-up call for anyone treating bond conditions like suggestions. But tell me, do you think the judge made the right call here, or would you have given him one more chance to prove himself? Thank you for watching, guys. Make sure to like and subscribe as always, and take care.